Welcome to episode 13 of K-Talk's Blackletter series. I am Professor Dan O'Gorman.
I am Steve Maxwell.
And on this episode, we are going to talk about contract interpretation, the meaning of language. And Steve, I know you have a soft spot in your heart about the what is chicken case. We'll talk about the so-called what is chicken case and how to determine its meaning. So let's start right off the bat with situating where we are. I assume we are at a point in time where the plaintiff feels fairly confident that if they can establish that a particular word in a contract has a particular meaning, that they are going to be able to establish that the defendant breached the contract, defendant failed to do X, and the question is, did they have a duty to do X? And a lot of time that relates to what does contract mean? How do we interpret terms? Now, we are going to be discussing something that is very similar to the parole evidence rule. Many courts, professors consider this an aspect of the parole evidence rule. I happen to be on the side of the fence that likes to keep it distinct. But Steve, you know me, I'm a big fan of what fences make good neighbors. Let's keep things separate. Let's not mix things up. So I like to think of it as different. But let's start with a situation. Let's say that we have a written contract, and that contract has a word in it. And the big issue is, what does that word mean? And how that is decided is going to dictate whether or not the plaintiff is going to win or the defendant is going to win. The first question is going to be, is that word ambiguous or is it not ambiguous? And when I say ambiguous, what do you think? How would you define ambiguous?
I think before law school, I think ambiguous was something that was unclear or open to multiple interpretations that are all reasonable interpretations. So that's kind of my prior to law school notion of ambiguous.
You're making me a little nervous because it makes it sound, because I was your contract professor, and you're making me feel like maybe that definition you brought to law school somehow changed. And I actually liked that definition, even as I sit here after 14 years of teaching contracts. So I'm very nervous to ask the next question, but I will ask it. Did your definition of ambiguous change after you went to law school?
Yes, I think it got a little cynical actually in law school. Imagine that. So law school making one cynical. I know it's a bit of a stretch.
Hey,
but
it's a living. It's what we do.
Right, exactly. All the day's work.
I peddle cynicism.
I'm buying. Is it movable goods? I don't know.
Right.
So I think I've kind of grown to say it's ambiguous if a party really needs it to be ambiguous. There is probably a way to spin it as ambiguous. Maybe that's a little too cynical.
Horrible. I think you're only supposed to learn that after you graduate from law school and become a lawyer. Are we actually teaching you that before you're an actual lawyer? That's terrible. Okay, so you obviously are laying a lot of stress on the fact that before law school you had an adjective that you were applying to capable of meaning more than one thing. You said reasonably capable of more than one meaning. And it sounds like now you're not so sure that there is such a limit. It's just, could I argue as a party that it has more than one meaning, whether that is reasonable or not? This is actually a very important question you have raised. Who is right? Pre-law school Steve or post or in law school and post law school, Steve. So the restatement, and the restatement's a little out there, right? The restatement will tell you that ambiguity, that words only have meaning in context. That this idea that a word just in and of itself can have a clear meaning doesn't make a lot of sense. And so this concept of, well, ambiguity only means that it has a reasonable meaning or something like that, they don't seem very on board with. But I think most courts are going to define ambiguity as meaning reasonably capable of having more than one meaning. And let me give you an example. For the word for. Now, we can have an interesting debate about this, right? We have an interesting debate about the word for. Would you say that the word for, F-O-U-R, is reasonably capable of having more than one meaning?
This feels like a trick question.
It's not a trick question. And you've already got me, I'm already crying, basically. I'm tearing up. I'm so sad about what we did to you in law school. This is not, you sound like my students now. The problem with when you try to corner your students and press them is then they never trust you ever. It's like the boy who cried. They don't trust the boy who cried wolf. I just ask them a regular question and I'm not trying to trick them and they're very nervous. I'm not trying to trick you here, Steve.
I'll say yes. It seems like it's unassailable in its interpretation of for.
For means four. Four can't mean three. The only way I think maybe four could mean something different is if we agreed it did. That you and I said every time I say the word for, we mean three. People probably do stuff like the secret code, for example, which is why it's hard to crack the code because the words don't have the meaning that would be reasonable. So, but most courts would say that words can only be stretched so far. That to be ambiguous does not simply mean that a word is a party gives it a meaning that somebody else doesn't, because that would mean every word potentially could be ambiguous, but that it have a meaning that is reasonably capable of having more than one meaning. Now, if that is true, then that is going to mean that there are some words in a contract whose meaning it cannot be altered. It is what it is. And a party cannot come into court, well, they can, and argue that four means three, but they're not going to get away with it because four cannot reasonably mean three. There is a limit to the malleability of the meaning of a term. There is a remedy in this situation. If the parties intended to write three and they wrote four, it's a remedy called reformation, which is ask the court to actually revise the contract. And I don't mean actually, they don't bring up the contract, they got a pen. Not actually like that, actually in law. And they will actually declare that four now means three in the contract. But so I think there is a limit. So I think most courts are not as cynical as you became. But the big question is how broad of a concept of reasonably capable is one going to have? My guess is you came out of law school thinking words can reasonably mean more things than maybe you had ever thought coming to law school. Is that fair to say?
Yeah. And I think it's one of those things where you just get so caught up in the ambiguity of law school and of legal doctrines and how flexible these things can be that you sort of lose sight of the clarity of what you had coming in, kind of like as you described with four. You're just sort of trained to question everything, and then you never learn to reconnect with that clarity. And I think a lot of people go through that after law school.
I think and I can't remember what Holmes wrote a letter to his parents. It may have been, I can't remember, it was in the Civil War. I think he was trying to mess with him, is arguing that he could prove something basically like that four means three. This kind of what do words mean, and they don't there's no such thing as having a true meaning of a word. And so there is some of that. But let's talk about what courts are more willing to go with that idea that words have a greater range of meaning possibly than say other courts who are going to try to have keep much more containment on the malleability of words. And let's talk about the incentives, the good and the bad of having a broad concept of the possible meanings of words versus a more narrow, where we're going to avoid having an expansive possibility in terms of meanings of words. If what would you say the benefit is? I guess I'm sort of asking you again to put on your kind of, your economist hat, your efficiency views for a court that is going to say, we are not going to entertain a lot of the nonsense you were just trying to peddle. You're peddling this idea that words can mean so many different things. Why might a court not want to entertain this concept and stick more to the traditional meaning of words, more like, hey, is it in the dictionary or not?
It creates some clarity for the parties. The parties can predict, if they choose certain words, that those words will be enforced in what that party intends to what meaning that party intends to infuse those words with. And if a court is too liberal in its interpretation, it may kind of prove one of those gotcha moments of contracts where we put this word in, that's what we meant, and now a court is infusing it with some other meaning that's a little bit on the unpredictable side, and diminish commerce in a sense that, well, now we agree to have, X number of chickens, and we can't enforce that. It's an interesting problem for a company or a party to deal with from an economic perspective.
If you think about it, Steve, why did we reduce that contractor writing? It reminds me a little bit of the parole evidence rule, where parties reduce agreements to writing to avoid parties from the other party from coming and saying, well, we had more terms to the deal. The whole point of a so-called integrating was to avoid those sort of factual issues. And if you think about it, that's also the reason why we would integrate, is not only to make it clear that maybe say these are the terms or the other, there's no other terms, but we pick our words when we integrate with a purpose. We select those words because presumably we believe that those words are doing the best they can, or at least somewhat close to encapsulating what we intend. I mean, we integrate and pick the words for a reason. And if you're going to sort of ignore that we chose this word and say, well, that word has so many meanings, it could mean this, could mean that, in some respects, perhaps it is defeating the very purpose that the parties had in putting the agreement in written form and selecting their words. Now let's talk about what might be bad about a narrow view. So the good view, as you pointed out, is predictability. You don't have to worry about the other side coming along and saying, well, when we said 4, we really meant 3. What might be the bad side, though, the negative consequences of having a too narrow concept of the meaning of words?
Yeah, I think that might arise in not so much technical or legal language, but layperson language and an agreement. I think that's where lay people can use a word in multiple ways, and the party has a certain meaning in their mind, but is not really aware of the plethora of ways that can be used outside of that context, and it just could kind of muddy the waters unintentionally or intentionally, and it's interesting. But what's your take on that?
Yeah, no, I agree. I mean, if you think about it, the problem arises where, let's say we use a word and you and I both intended at the time that we use that word for that word to mean X. But it's a little bit different from how most people would use that term. most people would use that term to mean why. Well, the problem now is if the court is too narrow of a concept of meaning for a word, that court might be likely to say, well, we're going to say that means why, because most people would think that term means why. And there might be really good evidence that the parties to the transaction intended it to mean X. And if the point of contracts in contract law is to enforce the deal that the parties intended to create, particularly when they both intended that, the same thing, it defeats the purpose of contract law in part. And so it could create injustice. We could have a deal being enforced in a way neither one of us intended it. And what's the sense in that? But the downside, of course, is then you lose that predictability potentially. You're assuming that we can feel pretty confident of what we both intended at the time. But somebody, like you suggested at the outset of this discussion, one party might just simply be coming in there, I think this is what you were suggesting, come in there and say, oh, no, that's not what I meant. And maybe they're fabricating it. Maybe they're just now taking this position because things have changed and they want it to mean something different. So we don't have truth serum. And so there's a risk of allowing parties to advocate for a meaning of a word, which is a bit off the beaten path. Because now you're starting to wonder, is it possible in the name of trying to enforce the deal that we think the parties intended, we're running too great a risk of not enforcing the deal that the parties intended? We're being tricked, we're being duped, or maybe one party thought that, but the other party didn't, and that's not fair, because the party who attached the more rational, reasonable meaning should probably be protected. And it's also very expensive. You got to litigate. You got to have evidence. If I can just crack open a dictionary, just figure out what most people would think this term means, that's a lot quicker and less expensive, but it also may lead to injustice. So what's the right answer?
Well, the right answer, well, it depends.
Yeah, and in large part, it depends on what jurisdiction you're in. So let's talk about the different approaches that the courts will take. There is a difference between two approaches to determining whether a word is ambiguous. And let's start with this idea that if the court concludes that a word is unambiguous, the court will enforce its unambiguous meaning. Now, this requires one to be on board with the fact that some words, there's a breaking point to stretching the meaning of a word. If you're on board with that, then let's talk about how the court, and I think the vast majority of courts are, that if a word is unambiguous, they're going to apply the unambiguous meaning. If you don't like it, ask for a remedy called reformation. So now the question becomes, how does a court decide if a word is ambiguous? How does a court decide if a word is reasonably capable of having more than one meaning? There are two approaches. When you're dealing with an integrated agreement, meaning a contract that has been reduced to written form, the first approach is something called the plain meaning rule, also called the four corners rule. The other approach is something called the context rule. The difference between these two approaches is what evidence will the court consider in deciding the threshold question of, is a word ambiguous? Is a word reasonably capable of having more than one meaning? Under the plain meaning rule, also known as the four corners rule, the court decides this threshold question by simply reviewing the integrated agreement, the written contract. It does not consider any evidence that we would call extrinsic evidence, which is evidence outside the written contract, outside the four corners of the document. If the court, after reviewing the written contract, and it is the four corners, which means if it's a 20-page contract, the court can review all 20 pages. So there is some context to the word. The word is not in isolation. There is context in a sense. but it's only the context that the court would learn or gather from reviewing the writing. And when the court hears the question, what's the issue? The court always gets to know what the issue the parties are fighting about. And that's not it. That's not extrinsic evidence. That's just what's the fight over. What are the two asserted meanings that the parties are fighting over? And the court reads the contract. And you know what? The court can have one other thing too. The court can have a dictionary. I know the issue. I got the contract and I got a dictionary. And I could probably have a Black's Law dictionary, a medical dictionary, an accounting dictionary, whatever dictionary. And I review, I look at the word and I know the issue and I look at the dictionary and I look at the context of the writing. If I decide that word is not reasonably capable of having the meaning asserted by one party, then the other party's meaning and only the meaning asserted by the other party, that we would say that word has a plain meaning. We've reviewed the four corners with a dictionary and concluded that that word has a plain meaning. That plain meaning applies because the word then is unambiguous.
That strikes me as more of like the court's attempt, that interpretation that strikes me as being very objective, trying to go for an objective meaning for a word. Am I wrong in interpreting that test objectively?
I think you are very correct to do that. Now, so the court is, you're not hearing about what the parties actually intended. You're not hearing evidence of what they intended. That's extrinsic. What the parties intended a word to mean is evidence outside the writing. It's the party's state of mind. I get to know what the fight is because, I need to know when you're talking about the word high. Obviously, the word high has multiple meanings. But when I read a contract and, it says that, there's something should be high, the employee should be high. There's a good chance from reading the contract that I understand they're talking about he needs to be elevated, not that he needs to have a buzz. And so what I get to know the issue. The fight is, was the employee supposed to have a buzz or is the employee supposed to be elevated? Physically elevated, mentally elevated. And so it is trying to get, you're not asking about the subjective. You're asking about, well, what do I think? What would the reasonable person think this word means in this situation? And the reasonable person doesn't think a word can have an unreasonable meaning. Now, it is interesting because what the context rule people, which is our opposing view, the so-called context rule, which we'll talk about in a second. The context rule people say, plain meaning rule, four corners people, you actually have some context. The context you have is the four corners of the document. Context includes looking at other terms of the contract, seeing that when you use the word chicken in a written contract, that it deals with the sale of a chicken, not the painting of a chicken, and this is context. Why is that context okay? And context outside the writing, not okay. But yes, it is more of an objective approach. So let's now talk about the contender, the rival, the so-called context rule. Steve, the context rule is very groovy, very West Coast, I think. I have a question for you, Steve.
Sure.
Hey, man, what is a word anyway? What is a word? I really feel like it should probably be part of our, our new spin-off podcast, Subtle Difficulties. What today on Subtle Difficulties? What is a word? We're joined by Steve Maxwell, who's at the University of Miami School of Law. Steve, what is a word?
Well, Dan, thank you for having me. It's great to be here.
Oh, welcome. Thank you. Thank you for being here.
I think a word, if I had to define a word, it would be a string of letters that has significance in a given language.
Fascinating. Yes, yes. And I do want to say this. I've read your book, What is a Word Anyway? And that was fascinating. And so are you suggesting, Dr. Maxwell, that words only have meaning in context? Would that be fair to say, or did I get that wrong?
No, I think you're within the letter of the law here.
Oh.
Words have meaning because the letters that make them up have significance in the context of that string of letters. And I go into great detail in my next book, Word to Your Mother, a lot more in depth into this very topic.
Yes, I very much. I've got it's on pre-order now. I think is it. We've got it. We'll have to have you back. And of course, what is a word anyway? I mean, everyone knows it was a New York Times bestseller. Is it Steve? Who created language? So language. Can you talk a little bit about did it come on high? Did it come from a divine being? Who created language?
It's a fascinating question. Going back millennia,
Mhm.
truly. And I can't say that there's one single answer to that question, of which I'm confident enough to write at any length.
Indeed, and well said, well said. And my understanding is that language was created to communicate ideas, thoughts, things. There's the bear. I assume when you scream, "Hey, there's the bear," you picked the word bear to identify a particular creature, right? So this is helpful. When I say, "Hey, there's the bear," you know what is coming. You should run, not run toward it, but run away. And so there's this idea. The context rule is built on this idea that words only have meaning in context. Words serve our purpose. We created language. When people use words, it is to convey an idea. And the question always is, what idea was the person or parties trying to convey when they used a word? And words cannot have fixed meanings. Like language is always changing. This is very distressing to me, Steve. I don't even like to talk about it. I'm so upset about it. So, my daughter's generation will say things like, I literally died, right? I literally died. They see nothing wrong with saying that. People like us, it's nails on the chalkboard, right?
Right. That's absolutely true. I mean, and think about how things evolve. Like, there's a bear. There's the bear. If that's preceded by, honey, I have a headache, there's the bear could be pointing to some aspirin. So who knows? As time marches on, so does language.
Exactly right. And my understanding now is, I believe, I don't know which dictionary it was, has now added literal can now mean not literal. But you know what I mean? We're going to go round and round. But it means figuratively, but I'm being quite serious about it. I'm having a hard time with the language here, Steve. See what problems this is causing to change the word literal? I don't even know how to describe it, because all of my definitions of literal mean literal. Well, you know what I mean. Stop that. Cut it out, Steve. You're twisting me around. You're twisting my word. But so the context rule is this idea that words only have meaning in context. And you know what? As a strong supporter of the plain meaning four corners rule, you know what I have to say to that? I agree. I'm ready to concede it. I don't think anybody in their right mind believes words have fixed meaning. I don't think the plain meaning crowd thinks that. The plain meaning crowd is just like, yeah, okay, look, but do we really want to spend a bunch of money trying to discover an unreasonable meaning? I get it. The parties may have said, use this word in a bizarre way. That happens. We can talk about in re soper, what is white, but is the candle worth the game, so to speak? Is it really worth spending the time trying to figure it out? So to me, it's not a debate over do words have fixed meanings. No, of course they don't have fixed meanings. That's why dictionaries change. Dictionaries are just compilations of the way people are using words. I mean, I don't think there's like some guy named Merriam-Webster. Is there a guy named Merriam-Webster, a man or woman named Merriam-Webster, who is like sitting on the cloud somewhere announcing what words mean and the words have these meanings and we must follow it? Or are they just recording documenting the way people use what people mean when they use words? So these are debates. So the first thing you want to think about is, if you are trying to analyze a word in a contract, is does your jurisdiction follow the so-called plain meaning rule? Where in deciding whether a word is ambiguous or not, will they simply look at the four corners and decide it in the dictionary and decide if it's ambiguous? Or will the court hear extrinsic evidence? Because that's what the context rule does. The context rule says, look, since words can only have meaning in context, in order for me to know, as the judge, whether or not a word is reasonably capable of meaning either of the asserted meanings by the parties, I need to hear the context in which this word was used. Was it a headache? Or are you in the forest, in the campsite, to know what the word, when someone says bear? So that's the context rule. The context rule actually hears all relevant extrinsic evidence. Tell me the story. You sit down. Tell me the story. Let me hear the evidence. Where were you? What were you? Why are you saying you said this? What had just happened before? All of that is relevant to deciding if the word is reasonably capable of having more than one meaning. Now, I think it's fair to say for most jurisdictions in the context rule is, if after hearing all that extrinsic evidence, the word is not reasonably capable of having more than one meaning. Like, I don't know that 4 is capable of meaning 3 unless the extrinsic evidence is we speak in code and we had an agreement that 4 meant 3. It ends there with the unambiguous meaning. But if after hearing all that evidence, the court concludes it's reasonably capable of having more than one meaning, well, now we are going to hear all that extrinsic evidence again, not to decide whether it's ambiguous, but to actually now give it meaning. And this is very different. The first question is just, is there enough here, enough smoke, that this word could reasonably mean more than one thing? So you're not like trying to parse through all the evidence to make a decision on what the word means at this point. You just want to hear, is there enough smoke here to make the word ambiguous? Whereas a plain meaning crowd, they may conclude a word isn't ambiguous because they're not seeing all that smoke. But note, if the plain meaning crowd, after reviewing the 4 corners, concludes that the word is reasonably capable of having more than one meaning based upon a review of the 4 corners, then, and that it is ambiguous, then they are in the same place as the context rule would be upon finding it's ambiguous. So in other words, this is just a threshold question where there is a division of the courts. Once the court decides it's ambiguous, I don't care if you're plain meaning jurisdiction, I don't care if you're context rule, we're in the same place now. Bring me all the relevant extrinsic evidence. I'm going to look at the intrinsic evidence, I'm going to look at the extrinsic evidence, and I'm going to go through the process of figuring out what this word means for this particular case. So
now, Dan, on that topic, like we talked about in our previous podcast on the parole evidence rule, is this threshold question answered only by a judge, or does a jury get to hear this?
Check your jurisdiction. It seems to me, so generally it's going to be an issue of law. So generally most courts are going to say, if a word is, deciding whether or not a word is ambiguous, has a plain meaning, is going to be an issue of law. You'll see many courts say that contract interpretation, when it's a written agreement, the meaning of a word in a contract is a matter of law for the court. There are even courts that will say, if the word is ambiguous and the extrinsic evidence is not in dispute, that the question, the meaning of the contract language, is a question of law for the court. So now let's say, well, when does a jury get involved in interpretation issues? Well, obviously, if extrinsic evidence is coming in and it is disputed, he said the chicken meant this, I never said that. Now the jury, as the fact finder, if it's a jury trial, is going to get to decide whether that actually happened or not. And generally, you're going to have a general verdict form. You're not going to have special interrogatories where they say, specific questions. What does this word mean? And then if they decide that, then it goes to the judge. It's generally just all, we're going to hear the extrinsic evidence. Part of our decision is going to be, what was extrinsic evidence? Is it true? Is it false? And then as part of that, we just decide the case. We never have to explain typically how we ended up with that final result. The one that's a little more complicated is if the extrinsic evidence is not in dispute, but the judge decides that a reasonable person could draw different inferences on the meaning of the word, even though the evidence is not in dispute. There will be courts which will say that should go to the jury because the jury gets to decide which inference is more reasonable. Whereas I think there'll be some courts which will say, if the evidence isn't in dispute, it is up for the court to decide which meaning is more reasonable because there's no facts to be decided. So the answer to your question, Steve, is check your jurisdiction. Because I think courts can kind of be all over the place on this. So it tends, though, to be, that first sort of question is generally an issue of law, I think, for the court for the most part. Once it's decided it's ambiguous, I think many courts will kind of send that then to the jury to decide which meaning is more reasonable, what inference is more reasonable. That's sort of my sense, but it's very jurisdiction by jurisdiction. All right, let's talk about the situation in which a word has been declared ambiguous. So once a word has been declared ambiguous, we now know that extrinsic evidence can come in, relevant extrinsic evidence. So what is that? So relevant extrinsic evidence can include things like what the parties said to each other during negotiations. Hey, we agreed that chicken would mean this. And let me mention, a way to avoid all this is to have a definition section in your written contract defining words that might otherwise be ambiguous. If you have the word chicken in there and the word chicken is going to be ambiguous, you can avoid this problem by simply having a definition section that says chicken, as used throughout this contract, means young chicken or means young or old chicken. Parties can always seek to avoid the fights over meaning by simply being clear in their contracts as best they can. So extrinsic evidence means bargaining history. What did the parties say? It can mean, it can be, so there's extrinsic. Intrinsic means what's in the writing. That's always really the most important. What word did they use? What's in the writing? Bargaining history. What did they say? It can include things such as course of dealing, which is, have the parties had agreements like this in the past where they used this word, and how did they use this word in the past? It can include things such as usage of trade. What is customary in the business? Maybe not these parties, but how do people in this business generally use this word? That's relevant extrinsic evidence. Course of performance. Did the parties seem to act in a way as they performed this contract that indicated they intended this word to have a particular meaning? This is all potentially relevant extrinsic evidence. But let me talk about the first question. The first question is supposed to be, after it's ambiguous, is, does this evidence lead to the conclusion, both the intrinsic and extrinsic, lead to the conclusion that the parties more likely than not intended this word to mean the same thing? And if you think about it, if the court actually believes that's the next question, their statement says that's the next question. Old school would not be very interested in this question. But if a court believes that's the next question, really at that point in time, that almost has to go to the fact finder, because the fact finder is trying to determine intent, actual intent, subjective intent. So we're trying to figure out, did the parties have a so-called meeting of the minds? I don't like that phrase very well, but it's appropriate here because we're trying to figure out, do we think the parties intended the word to mean the same thing? But the reality is, most of the time that gets kind of ignored. I think we just assume the parties had a misunderstanding. If it's ambiguous, we take what they're saying at face value, and we kind of ignore that question. I mean, how often do you talk about that on a bar essay? Do they have the same intent? I mean, I don't.
Yeah, it's not often, but a question in my mind is arising. Like, how do you know you're fighting over contract interpretation versus someone wants to assert the defense to formation of mistake? Am I right in saying, differentiating it by saying, if somebody wants out of the contract, they're going to assert the defense of mistake and go for rescission. If they want to charge the other party with breach, they're going to argue the interpretation issue as opposed to mistake. Am I right on that, or am I in the ballpark?
No, you're in the ballpark. And the reason why this is complicated is that these two issues intersect. So let's talk about, so you're talking about like the famous case, Raffles v. Wicklehouse, the peerless case, the two ships peerless is an example. We enter into a contract where we agree that you're going to sell me cotton coming on the ship peerless. And the problem is, there's two ships departing from the same port, roughly within the same time period, both named peerless. And you intended it presumably to mean one ship peerless, I intended the other. And presumably this is significant because they're arriving at different times. And the market price for cotton is fluctuating a lot, particularly at the time, because it was during the American Civil War. The price of cotton was fluctuating based upon the likelihood that we thought the North or the South was going to win the war, because there was a Union blockade. I mean, I don't need to go too much into that, right? So if the parties, so that deals with the meaning of a word in the contract. What does peerless mean? And you say it means one thing, I say it meant another thing. And the question is it simply an issue of contract interpretation? Well, yes, it is. What meaning are we going to attach to the ship peerless? The ship peerless leaving in October, or the ship peerless leaving in December? And this will answer the question as to whether you, the seller, breached or not, or I breached. So if each one of us, each one of our meanings was equally reasonable, then we would call this a so-called mistake in the expression of assent. And if you think about it, if each one of our meanings is equally reasonable, what is to be done? The court can't do anything. If it's too close to call, the court can't pick a meaning. And so when there is a material term in the contract, a term that obviously matters, that's relevant. So that would be potentially a fight in the peerless case. Does it really matter which ship? Well, I guess so, because they're arriving at different times and the price of cotton fluctuates. If it's a material term and each one of our meanings is equally reasonable. So peerless could mean October peerless, it could mean December peerless. But we look at the extrinsic evidence, and the extrinsic evidence results in it, wow, too close to call. The court is unable to give a meaning to the word peerless. And in that situation, we would say that there has been a mistake in the expression of assent and no contract formed. So that's, I believe, the doctrine you were referring to. So what could happen is, in a lot of these fights over what is chicken, what is peerless, what is wife, what does safe mean, you could end up with a situation where if it's a material term and the meanings are equally reasonable, the court's conclusion would actually be that no contract ever formed at all. And so it's very hard, because that means if you're analyzing formation issues, you also at the point of formation have to interpret the contract. And it seems weird to be engaging in interpretation at the process of contract formation analysis, because you think, well, surely interpretation comes after formation. Why would I need to do interpretation until after I know a contract forms? But because of this peerless doctrine, you are, in a sense, required to do interpretation to figure out if a contract formed. And I can tell you that this is something professors, we don't know where to put this. Some professors put it like right at the beginning in formation. You're reading about, Rickles v. Waffle House, Raffles v. Wickle House at the beginning in formation, but you don't know anything about interpretation. Like, I don't really understand how we figure out what peerless means. Well, you learn interpretation. So fine, kick the can down to interpretation. Then you're reading interpretation. Like, oh, wait a second. No contract forms? Oh, yeah. So you got to go all the way back there and no contract form. So we don't know what to do. We just kick it around. We don't know where it goes.
That's so interesting, because I'm thinking on the bar side of this, thinking, oh gosh, I don't know where to put that. Like, I think of it as contract formation with defensive mistake. So I'm sitting here thinking, okay, this just depends on what remedy the plaintiff wants. But it sounds like the peerless case is really that doctrine where the contract is not formed, that mistake is a very limited doctrine where you've got like that very unique situation of two equally reasonable meaning that may not apply to most other situations where this interpretation issue arises.
You're absolutely right. See, it's like Bigfoot. I think we have 3 credible sightings. Okay. So we don't have many credible sightings of the peerless doctrine in play. We have, of course, the famous peerless case, of course. Then there is, we can probably find more. I mean, it's not like I've done like a bunch of research finding every peerless case. There was a case out in New York, I think called Flowers, where it was the painting of an apartment. And it was, what does it mean to paint the apartment? And apparently the evidence was some as well as the outside of the building was as reasonable as outside and inside, and it was too close to call. And so it's like under the peerless doctrine, no contract ever formed. Judge Friendly, in the famous Fergalama case, What is Chicken, later said in a footnote, I think in another case, that he wondered if he should have decided the What is Chicken case under the peerless doctrine, that no contract ever formed, because each party's meaning of the word chicken was equally reasonable and no contract formed. Now, who am I to disagree with Judge Friendly? But there was no counterclaim. Who cares if a contract formed or not? In Fergalama, What is Chicken, the plaintiff sued for breach. If I recall, it was the Swiss buyers suing the New York sellers for breach. The New York sellers weren't suing the buyers for breach, and I may have it switched around, but there wasn't a counterclaim. So there's not a counterclaim. All you need to figure out is the plaintiff's asserted meaning the one we're going to go with? Because if you think about it, there's 3 things that can happen. Plaintiff's asserted meaning prevails, defendant's asserted meaning prevails, or it's a peerless case. They're both equally reasonable and no contract forms. The only time I think you would generally care about no contract forming in the middle is if both plaintiff and defendant are suing each other. You got a counterclaim. Now we got to decide, is the plaintiff's version or is the defendant's version more reasonable? And we might not be able to figure it out, and then it's a peerless case. If only the plaintiff is suing, all we have to ask is the plaintiff's meaning more reasonable? Who cares if the defendant's was more reasonable? It's irrelevant. They don't have a counterclaim. So we don't have many sightings of the peerless doctrine. I will tell you this. It is different from the mistake doctrine that most people are familiar with, which a contract forms, but it is voidable. So if I'm going to sell you a cow, it's Shirley V. Walker, and the cow is with calf, but neither one of us know it, and we're selling this beef cattle, then we made a mistake. We both believe it is Bayer. We both believe Rose II of Aberloan. It's almost obligatory to say Rose's full name, isn't it? Rose,
Yes.
it is. Rose II of Aberloan, we both think is barren. We've made a mutual mistake. That does not mean a contract doesn't form. That means a contract forms, but if the elements of the mistake doctrine are satisfied, the contract is voidable. And you may say, well, who cares? Well, you know why we care? A voidable contract can be ratified. It's still a contract. And so if the peerless doctrine applies, no contract forms. You know what this means? There's no gap filling. I got that question years ago. A student said, well, can you gap fill with the term if a contract fails under the peerless doctrine? No, you can't gap fill. What are you gap filling? There's nothing to gap fill. There's no contract. You can't ratify it. There's no gap filling. A whole host of maybe not a host of, but some issues arise, right? When you say it's no contract forms versus avoidable contract forms. And don't mistake a mistake in integration is when we use the wrong word. That's reformation. So we have a variety of mistakes, but they're different. One mistake is we use the word and we meant it. I thought it meant this. You thought it meant that. That's what we call a mistaken expression of assent. And now we have to figure out what meaning is more reasonable. You have a mistake where we have like a clerical error, a drafting error, reformation, or one party lied about what the term means or what the contract said. That's type of mistake, and that's also misrepresentation. But that type of mistake, drafting error, leads to a remedy of reformation. The mistake where it's usually about something extrinsic, is that cow, not the writing, is that cow pregnant or barren, leads to a contract forming but being avoidable. Clear?
Thank you, Dan, because that was very confusing to me, because I can see these issues sort of overlapping in my head, and I'm struggling with it. So I'm sure some students are struggling with it, or don't know that they're struggling with it until they get an exam.
Well, and it's perfect for this subject matter, isn't it? Talk about the different ways in which you see the word mistake being used. There's multiple. Tell me the context, right? There's multiple ways. So when we hear mistake, I think most professors, when they hear mistake, they think of the mistake doctrine making avoidable some extrinsic fact. But it is also mistake in integration, mistake in expression of assent. And don't even ask me if parties can use the mistake doctrine to render a contract voidable when they are mistaken. A party's mistaken about how the court will interpret a word in the contract. So let's say that the interpretation issue goes against you, Steve. Can you now say, I made a mistake, just like I thought Rose was barren. I made a mistake about what the reasonable person would think. I want to void this contract under a unilateral mistake about what the word meant. The restatement says, yes, even California, though, California doesn't like this. California said that seems to go against the objective theory of contract. So there's all sorts of weirdness.
Even California draws a line somewhere?
Yes.
No. Oh my God.
Even an argument was made that you should go to use the unilateral mistake doctrine to void a contract because you were mistaken about how a reasonable person would have interpreted this word. The objective theory goes against you. And so you're like, oh, well, I made a mistake. Can I void this contract under the mistake doctrine? And even a court in California was like, that seems weird. Even to us, that seems weird. That's not groovy, man. We're groovy.
That's a true commentary when you're at Venice Beach and they're like, no, you're too weird.
Get off our beach. Acting like an old man. Get off our beach. You're too groovy. Keep going. Go to Hawaii for summer. You need to go west, young man. So, all right. So let's assume that the court has decided that a word is ambiguous. Then the court or jury at this point perhaps has decided that there was in fact a misunderstanding, meaning that the parties each attached a different meaning to the word, right? So they believe you when you say, well, I meant X and the other party meant Y. The next question that is going to be asked, and this is another one that's often sort of overlooked, did they have a shared understanding? That's that question about did they have attached the same meaning? You can call that a mutual understanding or a shared meaning. This does happen. We have spotted this. I used to teach a case where the parties were fighting over what the word market size, the phrase market size meant with respect to fish. And the court concluded, based upon all the extrinsic evidence, that the parties actually meant the same thing by market size. So now you don't even really ask what the reasonable person would have thought. The reasonable person is brought out to answer questions when there's been a misunderstanding, a true misunderstanding. Under modern law and restatement, if the court concludes, the jury concludes the parties intended the same meaning, we're going to go with that. So, and the court actually said, yeah, we think they both meant the same thing by market size, so we don't even have to ask for help from the reasonable person. And I think this makes sense. I mean, contract law words aren't supposed to be used in a way where you can now like take advantage. Like, like we were kind of talking about at the beginning, like we really don't want parties coming in later, do we? And sort of like pretending that, oh, I meant it to mean this just because I now want to take advantage of this other interpretation. That would seem to go against trying to implement the intent of the parties. But here's the next question that technically you're supposed to ask. Your statement will tell you to ask this question. And I think this makes sense. Was one party aware of the misunderstanding? So in other words, if you want to define misunderstanding as each party attached a different meaning to the word. So you meant X, I meant Y. If you actually knew that I meant Y, and I didn't know that you meant X, it seems wrong, doesn't it, that you let this thing go forward? You talked about at the beginning of this podcast about one word perhaps using ambiguous language, perhaps you're kind of suggesting strategically, maybe. If you know I think it means X, and you know that you feel pretty confident, you think it means Y, you're intending it to mean Y, you know I intended to mean X, and you feel pretty confident that your meaning is more reasonable than mine, aren't you being kind of a jerk to not tell me?
There's got to be a rule here.
You're so soft. Where's the hardest nail, Steve?
Well, but you know what? This is one of those law and economics principles where we do not want to incentivize this kind of bad behavior. This seems like a violation of the obligation of good faith and fair dealing. This is, that sort of principle where we're not courts shouldn't play gotcha here because, and so it makes sense that there's got to be some rule there that can save the the innocent party or the not malicious party, whatever you want to call them.
Indeed, right? And it comes back to this idea that if somebody can avoid a loss at a lower cost than the other party, right? We sort of talked about this with the duty to disclose, the haunted house case and all that business, which is if you know that your house has roaches or it has a latent defect, it's easy for you to disclose that. You don't have to spend, we're not asking you to spend money. We're just asking you to tell the other side. That's low cost. Whereas the other side would have to spend a bunch of money to have tests done and inspected and call Ghostbusters and Strambosky. So yes, exactly right. And we do have a rule. The restatement says that if one party does in fact know that the other party is attaching a meaning different from the one that the part of the meaning attached by the parties in the know, then the meaning that is going to be given to the word is the meaning attached by the party who didn't realize that they were not on the same page for the very reason you just explained. So that's technically the next question. I mean, my guess is that most bar exam essays, you're probably not spending much of any time on the question of was there a shared understanding and was one party in fact aware? My guess is that the facts don't tell you either of those things, and they're probably expecting you to jump to the next issue, which is going to be whose meaning is more reasonable, applying the ejective theory. Is that fair to say?
Yeah, that sounds about right to me.
Yeah. I mean, it would take a long time to talk about all this stuff, it seems to me, under time constraints. So let's assume now that we have a word that the court has declared is ambiguous, meaning reasonably capable of having either meaning asserted by the parties. Number two, the court concludes that they are both being honest. It was in fact a mistake, a misunderstanding. And number three, that neither party was aware that the other party was attaching a meaning different from the party. And before we go to number four, because now we're ready to go to the last question, which is where most of these interpretation issues land. I think the first big question is it ambiguous? Question one, and then question four. 2 and 3 are sort of just like real quickies. Question number one is interesting, that if a court applies a plain meaning rule, and doesn't hear extrinsic evidence, and extrinsic evidence includes what the parties intended, there could be really good evidence of a shared understanding. And if the court concludes, because it's a plain meaning jurisdiction, let's say, from a review of the four corners of the document, that the meaning has a plain meaning. And that is different from what the extrinsic evidence is saying was a shared meaning. That shared meaning does not get implemented. It doesn't get discovered. It doesn't get implemented because it is in fact extrinsic evidence. And I will tell you, we've seen this happen. I've seen a case. I used to teach a case out of Delaware where it was a question of contract interpretation. And the evidence was really, really good that the parties had intended a particular provision to mean X. Even after the dispute breaks out and the letters between the lawyers are all talking about this provision, that this provision basically means this. And then when the lawsuit came, the court holds, applying the four corners rule, that the term is unambiguous. And so it doesn't matter, because at that point in time, if it's unambiguous, all those letters going back and forth before or after doesn't matter because the word's unambiguous. And so we've actually seen cases where we can feel pretty confident that a shared understanding goes, I wouldn't say undiscovered, but it goes it is unimplemented and not given effect because of the plain meaning rule. I think the context rule is the context rule is probably not going to have this happen because extrinsic evidence includes probably these letters going back and forth. I think it's just much more less likely to happen. But assuming we got the 1, 2, and 3, now the question is, whose meaning is more reasonable? We have to ask the reasonable person what they believe, because we've got a misunderstanding. Both parties, it was a true misunderstanding. No one's lying, we've concluded. Neither party knew about it. Now the question is, should one party have known about it more than the other party? Now it's a should have. Their statement, I'm not in love with the way their statement talks about this. Their statement talks about, should one party have known about the other party's meaning, or should the other party have known about the other party's meaning? That's a kind of a clunky way to simply ask, in my opinion, whose meaning is more reasonable? Objective theory, interpreting language. So that's where we are at, the objective theory of contracts, and all extrinsic evidence is coming in, including to the course of performance, course of dealing, use of trade. It's all coming in. See, shall we talk about, this has been very boring. Shall we talk about some cases?
I love cases.
Let's do it. I want to talk about plain meaning versus the context rule. I want to see if our plain meaning crowd, can they hold on to plain meaning? If there is one case which will test whether you really are a plain meaning person and aren't going to go, you said, was it Venice Beach? I'm not familiar with California.
Yeah. It's where all the hippies hang out. And now the hipsters are there.
I don't even know what a hipster is. Was that a take on hippies? I guess it was.
It's a modern day. Right. Yeah. The hippies were like 60s, 70s. Hipsters are more like 2000s and on.
Got it. How do I spot a hipster?
Oh, usually they've got one of those little mustaches, and they do have like facial hair. They have like some retro. So you might see them carrying a cassette Walkman, that kind of thing. Retro clothing is really big.
I like that.
Craft beer all the way.
So when I see those T-shirts in the mall and they're like AC/DC, Rolling Stones, Iron Maiden, are they targeting the hipster crowd? No.
Maybe. I think those have other, like, those are hipsters and Gen Xers, I would say.
Got it. Okay. Thank you. I appreciate that. See, I've learned something too. So in Ray Soper, in Ray Soper. So in Ray Soper is maybe the greatest case of all time. In Ray Soper is this case where Ira Soper fakes his own suicide. He's married. He fakes his own suicide. And he right. So you're nodding because yes, it's coming back, right? You remember this one.
Not only do I remember it, I remember it so fondly because I don't. Yes, this has a lot of meaning to me subjectively.
Yes, indeed. So in Ray Soper, Ira Soper fakes his own death, a suicide, and he relocates. He leaves a wife. He leaves Adeline. And he leaves Adeline and he relocates to Minnesota and he ends up not really married. He goes through the marriage ceremony, he gets a marriage license, but it's not a legal marriage because he's still married to Adeline. And he marries Gertrude. And while he's married to Gertrude, he enters into a contract with his business partner, a guy named Karstens. They're in the oil business. And the partners, Ira, who's now known as Mr. Young, right? So he's got a different name. He's Mr. Young at this point in time. And they want to make sure that the business, if one of them dies, that the business will not go to the surviving spouse because they're concerned, presumably, that it's going to make it more difficult to run the business. So, I mean, and it kind of makes sense. If do you really want to all of a sudden have to do business with your partner's wife because you don't know her? You want to do business with your partner because you know your partner, and you don't want to have now somebody owning 50% of the business who you don't know and may have different views on the business. So they developed a plan where they took all their stock and they took the stock from their wives because their wives had a little bit of stock. They each were married. And they took all that stock and they gave it to a trustee. And they entered into a contract where they agreed to put all the stock to the trustee. And that upon the death of either one of them, all of the stock would go to the surviving partner. So the partner then would own all of it. So far, so good. But obviously, you don't want to be horrible to your spouse because your spouse is who would have been the beneficiary is losing. She's not just losing her little stock. She's losing presumably everything, half the business that she would have inherited, right? Because she would have inherited the stock. So they want to have protection for their wives. So they agree that the oil business will take out an insurance policy, pay it with the proceeds from the business, with directions to the trustee to distribute that the proceeds of the beneficiary under the life insurance policy is going to be named the trustee. So the trustee, the proceeds will land to the trustee. And then under the contract, the trustee is directed to pay out the life insurance proceeds to the decedent's wife. So far, I mean, you can see the problem. Of course, I've already told you the backstory. If I hadn't told you the backstory, I'd be like, no problem, all sounds great. Well, you can see this coming. Of course, Ira Soper, well, allegedly takes his own life. I mean, everyone always likes to wonder, did he really? Takes his own life. And the stock, now the trustee's got all the stock. The trustee takes all that stock and gives it all to Karstens. So now Gertrude gets none of the business. But no worries, because the life insurance company pays the proceeds to the beneficiary, which is the trustee. And then the trustee, according to the trust agreement and the contract, pays out the proceeds to the only person whom the trustee recognized or knew of as being Young's wife, Soper, aka Young's wife, Gertrude. So Gertrude gets all the money. A couple of years or so go by. Apparently, Adeline's brother discovers that Soper had not committed suicide earlier, had started this new life, and tells Adeline, and Adeline makes an appearance and says, that's my money. I'm the wife. I like to imagine like the courthouse doors fly open. There's like a shadow and it's to be continued. And then in the next episode, you see who it is. And it's Adeline. And everyone's in shock. Who's this person? And the fight is on because Adeline sues for a recovery of the proceeds, which have been paid to Gertrude, arguing that she is the intended beneficiary. She is the beneficiary because she is the wife. And the fight is on as to what does wife mean? And I love this case because it teaches multiple things. The first thing is students want to argue that wife means whatever the law says wife is. Well, yes, but we don't answer that question based upon what we think the Minnesota legislature defined wife as in the family law statutes. We're trying to get at what do we think the parties, Karstens and Soper, intended when they used the word wife in the contract. So it's their meaning that we care about, not some meaning of the legislature. And so that's question number one. And that goes to show students, interpretation is not about somebody else's intended meaning. It's about the meaning of the parties. Okay, number two, it brings up this great fight between the plain meaning rule and the context rule. And we have a majority opinion, and we do have a dissenting judge. And to make things confusing, they were both written by Judge Olson. Well, one had like an E and one had an O.
Wait, are these the Olsen twins?
Yes, I love these. May be right. Well, they're not the Olsen twins. It's Olsen with an O and then with an E. So this is the original Olsen twins, apparently, right? So not as rich as the current Olsen twins. So the majority says they say it. See, they say it way before. I don't know what Venice Beach was like in 1935, but this is 1935 in Minnesota. And this idea that words don't have meaning in isolation is alive and well. This is what the court says, things like this. You're ready? It says, the court actually says that to hold that wife in that contract meant Adeline would give the word wife a fixed symbol as something inherent and objective, not subjective and personal. So the court in Minnesota in the 1930s is saying words don't have fixed meanings. Words only have meaning based upon what we think the parties intended them to mean, the context. So we have to decide if this word is reasonably capable of meaning either Gertrude or Adeline. And note, all we're asking now is it ambiguous? We're not saying, is it Adeline? Is it Gertrude? That's not what the court's doing first. The first question is it ambiguous? And the court says, to know if a word is reasonably capable of having more than one meaning, we need to hear the extrinsic evidence because words don't have fixed meanings, only in context. We need to hear the context. And so when the court hears this crazy story about Soper and suicide, they're not deciding who Soper meant when he used the word wife. They're just saying, whoa, is the word wife in this contract? Do we believe it is reasonably capable of meaning Adeline or Gertrude? And the court says, yes. Hearing this crazy story, of course, yes. Oh my God, it could actually mean Gertrude. And then the next question for them would be, now that we decide it's ambiguous, we will hear all of this extrinsic evidence because all this crazy story, all this drama is extrinsic evidence. None of this drama plays out in the four corners of the escrow agreement. Then you hear all the evidence and the court concludes, well, we think if you heard this story, you could do nothing but conclude that Karstens and Soper must have intended wife to mean Gertrude, the second one, because that's the word, that's who Soper meant. When he used the word wife at that time, when he goes to a Christmas party for the oil company, does he introduce Gertrude as not really my wife, as my fake wife? Of course not. He says, this is my wife. He introduced that to the escrow, to the trustee, presented as, yeah, they're my wife. To Karstens, this is my wife. And so it becomes an easy case. Now enter the dissent, which argues for the plain meaning rule, which I think strangely most students actually like the plain meaning rule. Students tend to be not very Venice Beach, I've noticed. I don't know if it's because we talk about it. It's not because they're law students and maybe, and I think that might be changing, but you do get a fair number of kind of conservative, rule-oriented, I should say conservative, rule-oriented types. And the dissent's view was, the word wife is not ambiguous. The word wife, if you show me this contract and you ask me to read it and you asked me, does the word wife, is it reasonably capable of meaning more than one person? I would have to say no. Wife means who are you legally married to? I've got my Black's Law Dictionary. I've got my Merriam-Webster's. And it's not reasonably capable. It's like four. It's not reasonably capable of meaning someone who isn't your wife. They may use it that way, but that doesn't mean it's reasonably capable that way. And therefore it ends. And if it's unfortunate, well, that the parties, there was a subjective intent for it to mean something other than its reasonable meaning because it's a crazy story. Well, that's too bad. I guess we feel bad about that. We feel bad that Gertrude is going to lose her money to Adeline. But you do have to pay a little bit of a price for the plain meaning rule. And the benefit is this is cases 1 in 1,000. And should we really spend all this time hearing extrinsic evidence because this might be a 1 in 1,000? We're sorry, but that's what rules do as opposed to standards. They lead to injustice every now and then, but we've decided on balance that it's not worth the price. And so I will hand it over to you, Steve, your thoughts on in re supra.
Well, I think it's kind of, if you go with the dissent, I think you're sort of picking out a word that is just not capable of more than one meaning. And so you're almost saying, as a matter of law, if you use this word, it's always going to mean this. And in that respect, it sort of operates as a exception almost in interpretation. Am I wrong in saying it like that? I feel like that's just an exception for that word. And that just seems a little weird to me.
Well, you know what it reminds me of when you say that, but we could have other words, Steve. It doesn't need to be the wife exception. It could be the for exception. Right? I mean, we could probably come up with a lot of other words. It is interesting because I think what you're saying, wife is actually, so a wife, I'm going to say technically, see, it's very hard to have this discussion without are you a plain meaning person or not? And the words have fixed meanings. Is that so a dictionary probably has a threshold requirement for when a word's meaning is going to be officially recognized as changing or being added to. So let's say you're Merriam-Webster, and I say to you, hey, word is used in this way by me, so you need to change the dictionary. Because when I say wife, that's not what. When I use the word wife, I mean somebody other than my wife. I mean my cat or something like that. So you need to put, or your cat, Merriam-Webster. You'd be like, come back to me when a certain percentage of the population is using it that way, correct? So, dictionaries can't catalog every way in which a word is used by everybody, because it'd be great. But you know what's interesting is this concept of slang dictionaries and informal uses, because dictionaries start putting things, don't they? They start putting like slang. It's almost like they're sort of like agreeing that there's a thing where, okay, let's say some people use a word in a way, but there's just not enough people. And so Merriam-Webster is going to be like, well, we're not recognizing that. Come back to me when you've got 1%, 2% of the population. I don't know what the number is. And then I come back to you. I wonder, they say, and I said, yeah, but you guys are using it in a very sort of loose way, not like a serious way. So we'll recognize it, but we're going to put a disclaimer. We're going to put in italics informal use or slang. They also put archaic, right? When it's changing to longer, it's archaic. All these sort of qualifiers, which is sort of like Merriam-Webster acknowledging that there's gradations of meaning. And so I think almost what you're saying, wife to Merriam-Webster's, I think, is a legal concept. Wife describes a legal relationship generally, right? I mean, it's law tells you if you're married or not, right? A wife is somebody that the law recognizes you're married to. And so if the law doesn't recognize it, then you can't be the wife because it's a legal doctrine. It would be like a law dictionary question now. So what you may be saying is there like a law dictionary concept? But you could do this for science. My guess is, when I say, okay, I had a heart, let's say you and I use the word heart attack. in a broader way than science would. I say, this would always happen when you talk to an expert.
Mhm.
You're talking to a doctor and you say, yeah, my brother had a heart attack. And the doctor's like, yeah, it actually wasn't a heart attack. What was it? He's like, it was an angio, this, blah, 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 blah. I'm like, I don't know what that is. That's a heart attack. No, that's not a heart attack. You just call it a heart attack because you're a lay person. You're using it wrong. Not using it wrong because everyone calls that a heart attack. So I think that the question is, is there an exception, but is there a point in time in which we're going to say language cannot be bent and have different meanings? And the question is, when isn't it reasonably capable of more meanings? What situations? And what it also reminds you of, Steve, is this idea that there's a fight over what is a contract. Okay, so this is definitely getting a subtle difference. Steve, what is a contract? There is an idea, a debate. Is the contract the writing, or is it the legal rights and duties, which are intangible and just what is the court telling me to do? So the plain meaning rule is a bit based upon this idea that when we integrate and we put a word on paper, Steve, this is a sacred and solemn event.
Like a marriage.
It is, Steve. Exactly right. So the fact that we're going through this formality, we are losing control of what we've done. We brought, or like having a kid, you only have so much control at that point. We've created something beyond you and me, Steve. I don't get to define what my kid is once I have a kid. That kid is their own. I can try to influence it. I can argue what I intended. I intended my kid to be really smart, and compassionate. I should start with compassionate before smart, or not.
That was Freudian.
That was smart, then compassionate. I meant compassionate, then smart. Wait, no, smart, so that way they can use their intelligence to be compassionate, and change the world. So there's this idea that words have meaning beyond you now, beyond what the parties meant. Is this idea that no, it's not about what Ira Soper and what Carson's meant. Once they put it down in writing, they lost control of it. It's out there in the world. They put it on writing. They wrote wife. Wife has its own meaning. And if it's not the meaning you like, you should have used the word wife. Should have used a different word. Why'd you put that in writing? So you should be more careful versus, seriously, man, come on. That's not a contract. That's just evidence of our deal. A writing and the words we chose when we integrated is just evidence of what we intended. Our contract is what we intended. Now, at the end of the day, as Justice Holmes would have told us, what law is predicting what the courts will say the contract is. But that sort of goes back to, is the court going to say that the contract is what we think the parties intended and meant? Or is the court going to say it's the writing and you kind of lose control of it? So that's sort of the debates in a case like this. And so I think there's no right answer. The answer is check your jurisdiction. Is your jurisdiction a context rule, or is it a plain meaning rule? Most of the, Article 2 in its comments says words don't have fixed meaning. So I don't know if most places the comments aren't law, but this is a strong indication that most Article 2 drafters intended to have more of a context rule than a plain meaning rule. But so there is our debate. So just out of curiosity, who would you have ruled for in Ray Soper? Can we agree that more likely than not, Ira Soper intended wife in that writing to mean Gertrude Whitby, not Adeline Soper? Would you agree with that? You don't have to.
I would, because, who fakes their death to get away from the person that they want to benefit from the life insurance?
And I've heard arguments that, well, maybe he was feeling guilty, but that may be right, but we'll never know. But I think that if we're asking about a preponderance of the evidence, it seems to me that it's an easy case on preponderance. Preponderance is not beyond reasonable doubt. And we can all think of interesting reasons why he may have intended it to be Adeline. But I think, yeah, more likely than not, he meant Gertrude.
Right. I mean, wouldn't he have gone out of his way to tell the trustee who he really meant
Yeah,
if it wasn't the only person that the trustee knew as wife?
he sure is. If his intent was to go to Adeline, you're absolutely right. He would have like put it in like a safe, a safety deposit box, open upon death. He's really gambling that no one's ever going to know. If his intent is to get this money, you're absolutely right, to get this money to Adeline. This is a terrible way. I mean, how is it, he's just hoping that these events occur, that Adeline's going to discover it. So if we can agree on that, then how would you decide if you're on the Supreme Court of Minnesota? Who would you rule for? And note what's going on here. If you think you're a plain meaning person, but you would then say, well, I'm going to give the money to Gertrude, you're not really a plain meaning person, are you? I mean, you can't, if you're going to bend and create an exception when you think that the plain meaning rule leads to injustice, you're not a plain meaning person. You're not willing to bite the bullet, essentially. So with that said, your decision, Steve, is what?
I'm Team Gertrude all the way. And I think I probably would have said I was a plain meaning person, but I think plain meaning people really just want the plain meaning thing to work, but really aren't plain meaning people. Like, I think it's one of those things like you wish it was this way, but it just can't be that way. I wish I could have $1 million, but it's just not going to happen. It's just one of those things, disconnect between ideal and reality. That's my very controversial final thought.
Well, and you know what? And I think you are right. We want to make it happen, and you got to be pretty, pretty tough-hearted to really hold on to the plain meaning rule. I think what's really why this is such an amazing case is that the remedy of reformation it may not be available. Usually if you've got a mistake like this, like, oh yeah, this is okay, fine. Ha ha ha, wife meant Adeline, but everybody knows the parties meant it to mean Gertrude. Let's reform the writing. The problem here is that Iris Soper's dead. And now the remedy for reformation requires that it be proven by clear and convincing evidence to reform the writing. And now that gets kind of hard because, maybe we feel by the preponderance of the evidence that the parties intended it to be Gertrude, but both parties you must be shown by clear and convincing evidence usually that both parties intended it to be something different than what they drafted. And you wonder then, can you get there? I mean, I feel a little bit better about holding on to the plain meaning rule and being Team Adeline, at least for purposes of the interpretation question, if I felt comfortable that there was sort of this safety clause, which is reformation, to avoid the real big, when we really think there's something wrong here. But I don't know that we can get there because of the death of Iris Soper, which of course makes it such a wonderful case. So that is a great case to show the difference in play between the plain meaning rule and the context rule. Now let's talk about a case where we jump all the way to issue 4, which is what would the reasonable person believe? We're assuming that a word is ambiguous, that there was a misunderstanding, not a shared understanding, that neither party was aware that the other party meant something different. And this, of course, brings us to our case, our what is chicken case, because I know you want to talk about that. And see, if the big question in this case was, what does chicken mean? And I know you're going to flash a picture soon. This is Frégé-Lamont. My wife tells me it's Frégé-Lamont because it was a Swiss company. I always want to say Frégé-Lament. Frégé-Lamont Importing Company versus BNS International Sales Corp, which is out of the Southern District of New York in 1960. I feel like I'm like in front of the court. Your Honor, you'll find that case at 190 F Sup 116. And the very first line in the case decided by Judge Friendly, one of our most famous judges, his first question was, the issue is, what is chicken? And we have a buyer, a Swiss company that enters into a contract to buy chicken, cryovac chicken, from a seller in New York City, right? Well, they're from New York anyway. They're from the city. I think they're from the city, from New York, from the USA. And they ship the chicken. The chicken arrived, and the chicken are older chicken, only good for stews and broths or whatever. They're called fowl, pejoratively called fowl. And the Swiss are horrified. And I always figured this case is a problem here. The difference in cuisine and taste and love of food between the Europeans and people in the US. Is this the Swiss thinking that we are just horrible Americans who are like, a chicken's a chicken, and they're horrified that we would think that?
I think it certainly could be. I mean, I don't know anybody who's been on a domestic flight and compared it with an international flight. The cuisine is very, very different. So I can see the Swiss sort of going, oh my God, Americans call this food.
Oh, it's not even chicken, it's just food. Yeah. So the fight is on. And the fact that it is the Swiss, which last time I checked is close to France, it is just horrified that they would order chicken and get these, get this stewing chicken, this fowl, which is only good for stews, not good for broiling. And the Americans are like, what? It's a chicken. And I love this guy out of New Jersey. These sellers have an expert out of New Jersey who says that everything, he considers a chicken everything except a duck and a goose. So I guess you're a chicken, Steve. A cow's a chicken.
Yeah.
If it's not a duck or a goose, it's a chicken. It just seems to me like more embarrassment for us Americans, or is it we Americans, chickens. And the fight is on. And what does chicken mean? Now, there was a very interesting move here by Judge Friendly very early on, often overlooked by the students. The court, Judge Friendly, says that the word chicken is ambiguous. Now, that's a big move. He says, since the word chicken standing alone is ambiguous. At this point in time, I believe, this is New York, but I don't think New York at this point in time had adopted Article 2 of the UCC. So if a court believes that Article 2 adopts the context rule, that would not be in play here. And New York is famously a plain meaning rule. It's a big business center. It makes sense to have the predictability. And so presumably, I'm not an expert on New York law, but my understanding is this would have been a plain meaning question. And so Judge Friendly would review the contract and would have to decide on the face of the contract, the four corners, and with a dictionary, whether the word chicken is ambiguous. And he says, yes. Students are often surprised by this, but I think that means that students are forgetting that the plain meaning rule allows the judge to review the four corners of the contract. And Judge Friendly would have seen that this was a contract for the sale of chickens. He does see in some context, this is a buying and selling of chickens. And presumably, if you've got a contract for buying and selling of chickens, the word chicken can be ambiguous, right? You could be selling young chickens, this type of chicken, old chicken. Chicken, I assume Friendly believed that the word chicken could reasonably have different meanings in a contract to sell chickens. And that's why he held it was ambiguous. And once he does that, of course, now, assuming each party was acting in good faith, which Judge Friendly assumes, neither party knew what the other party meant. And neither party, both parties, one party believed chicken meant old or young, and the buyers believed it only meant young. Now, the question is, how would a reasonable person have interpreted the word chicken in the context of this deal? Because even the plain meaning rule, once it's ambiguous, the question now is, what would the reasonable person have believed the term meant, based upon all the extrinsic evidence, the intrinsic? You're at the same place now as the context rule. And all sorts of extrinsic evidence is going to come flooding in. Things like, what does the word chicken mean in the industry? Chicken experts on the word chicken in the industry, buying and selling, are coming in to testify. If there had been any prior contracts between the parties, which here there were not, that would have come in. Was there discussions during negotiations what word chicken meant? And yes, one of the agent of the buyer had actually said, yeah, chicken means any type of chicken, old, young, we use that word. Is the agent, but Friendly doesn't seem to say that's automatically going to mean that that's what the principal meant, but it's pretty good evidence of it. All this evidence is coming in back and forth of what the word chicken means. And at the end of the day, if it is the plaintiff buyer who is suing and they're the only one asserting a claim, the burden of proof will be on the plaintiff buyer to prove that more likely than not, the reasonable person would believe more likely than not that the word chicken meant the meaning they gave it, which meant young chicken and young only. And Judge Friendly says, the evidence is so close. That's why later he said maybe it should have been a peerless case. It's so close. I don't think that the buyer has carried its burden of proving that the parties intended the word chicken, or there is a person who believed that they'd intended the word chicken to mean young only. It doesn't mean that they intended it to mean old too, but it's just too close to call.
And, I think I see the point now on the peerless analogy, because you've got maybe some serious cultural differences with cuisine that are kind of, pardon the pun, boiling underneath. And they could very well have meant two different words with the same word chicken. And so I'm sort of coming around to that. Like, if I'm seeing it from that perspective now, understanding the international bend of this case.
And I think a lot of it did hinge on not just the fact that they had maybe different concepts of chicken, but you've got people speaking German, and and then people speaking English, and you may have a bit of a language barrier, which is going to contribute to that. The case is beloved by contrast professors because it gives you a really good example of the different types of context evidence, extrinsic evidence. Remember, the intrinsic evidence always remains the most important. What the party said, what's in the contract. Like in the contract, there was a reference to the USDA definition of grade A chicken, and the USDA apparently included within the definition of chicken older chickens too. So don't forget, students out there listening, and who else would be listening, of course, that just because you're looking at extrinsic evidence and it's admissible doesn't mean that probably the most important still is the words chosen and the evidence of what the parties meant in the writing, because the writing is kind of sacred in a sense. Even when you're looking at extrinsic evidence, it is our most important evidence of what they meant. And you had all this evidence going back and forth. You had some experts saying, no, it could mean old too. You had other experts saying, no. When you use this word, it means young chicken. And they're battling back and battle the experts, which often happens and probably tends to be a wash. You had things like the sale price wouldn't make sense if it was young chickens, because the seller would actually be losing money. And Friendly says, well, that doesn't make sense, that you think the parties intended them to lose money on this deal. And so you had all this back and forth evidence, and it's just too hard to prove if you're the buyer. More likely than not, the parties intended this, or the person would believe they intended this to mean just young chickens. And so I guess the lesson is for the buyers, be more careful. Now, I should note something, that there's this idea that some words are patently ambiguous and some words are latently ambiguous. Most people don't care a lot about this. But the restatement, we're really going down deep in the weeds here, because actually in a reporter's comment, which is not even comments, it's a reporter's comment, that when a word is patently ambiguous on its face, meaning that you look at it and you're like, oh, build a good house. What does good mean? And the contract fails because you can't give sufficient meaning to good, then your contract fails because it lacked reasonably certain terms. Whereas if it's latently ambiguous, which tends to be things like proper names, like the word peerless, then like on its face, it looks fine. You read the contract, yeah, peerless, on the ship peerless, that makes sense. And then extrinsic facts, you learn that there's two ships peerless, and you're like, that's weird because peerless means without peer. Who would think that there's two ships peerless? That's a latent ambiguity, and that fails under the mistaken expression of assent doctrine, the peerless doctrine. It doesn't really matter because the contract fails either way. It only matters if you're a really picky professor like I have been in the past. And so answer choice C is fails under the mistaken expression of assent doctrine. D, it fails under the lack of reasonably certain terms doctrine. There's never an offer, let's say. But generally it doesn't matter. The road is the same, no contract forms. But that was friendly later, as I said, thought, yeah, maybe it was both meanings were equally reasonable. So a contract never formed in peerless. Again, I've already told you what I think. Who cares? There wasn't a counterclaim. If there's a counterclaim, you have to decide that. Friendly must decide. Is it young chicken only? Is it young or old? Or is it too close to call? If there's a counterclaim, Friendly would have had to decide that. But he didn't because there was only a suit by the buyers. All right, Steve, any final thoughts on, as I flip through the book here, any final thoughts on giving meaning to words? And I don't know if chicken is patently ambiguous or latently ambiguous. I don't know if it matters, right? The reason you made me think of that was if it is latently ambiguous, it fails under the peerless doctrine. If it's patently ambiguous on its face, the contract would lack reasonably certain terms. I'm sure we don't want to launch into a discussion of whether the word chicken is latently ambiguous or patently ambiguous, do we?
No, I don't think anyone wants to hear that. But if anyone watching might want to see that you and I have been trying to figure out what a chicken has been for many years now.
We have a long history. We have spent a lot of time trying to figure this question out. And you have evidence of this?
Oh, I do. Let me I thought you had it there.
Oh, absolutely. Oh, yes, no, let's do it. Hey, I am going to hang on. I do. Here it is. Here it comes. Share. Can you see that, Steve?
There it is. That was back when I had hair.
Yes. I just thought you changed it. Is that what's going on? The truth is out. I thought it was a change in hairstyle, Steve. You shouldn't admit these things.
It's a recent recession, I think, is what we call it.
I like that. So there we are. So those who are listening on the podcast don't know what's going on, but if you're listening, I am sharing on the screen a photo of myself and Steve, and I am holding a crochet chicken that I've named Friendly, after Judge Friendly. That is Friendly the chicken. Friendly the chicken resides in my office. So I guess it is true that Friendly is not a free-range chicken. He's confined to my office, but he doesn't complain about it. And I think it's like Toy Story comes alive, or Night at the Museum comes alive at night. And that was crocheted by a student of mine, which is very nice. A student crocheted a chicken and gave me the chicken. I do not remember why we would be together here holding a chicken. Do you?
I think it was an admitted students' night, if I'm remembering correctly. But I think this Friendly here is neither a duck nor a goose, and therefore really is a chicken.
Well, all three of us would be chickens under that definition. We have 3 chickens in this picture. Is that right?
I concur.
And I think that makes sense that it would be amazing. I wonder if I did the what is chicken case.
Yes, you did. You did the what is chicken case in the open house, the admitted students night or something like that.
And clearly this is pro-COVID, pre-COVID. Now, this is not, don't send emails. This is not pro-COVID.
Yeah. Yeah.
Pre-COVID, because we don't wear masks.
Right. And we weren't on a screen either. It was a different time.
It was a simpler time, Steve, wasn't it? So that is very nice. So yes, this goes to show you that we have been debating the question, what is chicken? And I think students like the case because it's funny. They remember it. And when I talk about contract interpretation questions, I will call it do we have a what is chicken question here? there's a debate of what is rate, well, not radius, everyone knows what radius mean, but right, what does good mean? What is prompt mean? Whatever word it happens to be, I say, do we have a what is chicken question here? So I'm glad we were able to answer the question, what is chicken, as well as what is wipe. I hope you enjoy episode 13 of our Blackletter series on interpretation. Steve, any final comments, puns, anything?
No, I'm kind of hungry. I'm going to go get some chicken, but we'll see you in the next episode.
We will see you